Hello and welcome to Listen and Score. This is a channel which is here to read for you. Your job is just to listen and recollect and gather the points, whatever you have already studied or learned. So, this channel is going to help you in revising things. Today, in this video, we are going to discuss about Law of Contract 1, which is the syllabus of semester 1 LLB, and the concept may be helpful in answering the questions related to consideration and statement, like define consideration, an agreement without consideration is void, discuss statement, and explain the exceptions, if any, to this statement. Meaning, consideration. Anything given or promised or forborne by one party in exchange for the promise or undertaking of another in a contractual agreement. Definition. According to Blackstone, consideration is the recompense given by the party contracting to the other. Justice Patterson says, consideration means something which is of some value in the eye of law. It may be some benefit to the plaintiff or some detriment to the defendant. Section 2D of Indian Contract Act, when at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. According to section 10, all agreements or contracts which are made by the free consent of parties. Number 2, competent to contract. Number 3, for a lawful consideration. And number 4, with a lawful object. Hence, a lawful consideration is the most essential element of a valid agreement to become a contract. Agreement without consideration become void. Section 25 provides the same. As explanation to this section 25, we can take nothing in the section shall affect the validity as between the donor and the donee of any gift actually made. An agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate. But the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given. Let us see some illustrations. A promisee A promises for no consideration to give to B rupees 1000. This is a void agreement. A, for natural love and affection, promises to give his son B rupees 1000. A puts his promise to B into writing and registers it. This is a contract. A finds B's purse and gives it to him. B promises to give A rupees 50. This is a contract. A supports B's infant son. B promises to pay A's expenses in doing so. This is contract. A owes B rupees 1000, but the debt is barred by the Limitation Act. A signs written promise to pay B rupees 500 on account of the debt. This is a contract. A agrees to sell a horse worth rupees 1000 for rupees 10. A's consent to the agreement was freely given. This agreement is a contract, notwithstanding the inadequacy of the consideration. A agrees to sell a horse worth rupees 1000 for rupees 10. A denies that his consent to the agreement was freely given. This inadequacy of the consideration is a fact which the court should take into account in considering whether or not A's consent was freely given. Legal rules as to consideration. Number 1. To become a contract, every agreement must be supported with some consideration. Number 2. At the desire of the promisor, that is promissory estoppel, it is the promisor who is to move it. An act constituting consideration must have been done at the desire or request of the promisor. If it is done at the instance of a third party or without the desire of the promisor, it will not be a good consideration. So let's have a case study. Durga Prasad versus Baldio, 1880. So promissory estoppel. Brief facts. The plaintiff, on the order of the collector, built with his own capital some shops in the town. The defendant took some shops in consideration of the plaintiff having expended money in the consideration, promised to pay him a commission on articles sold through their agency in the shops. Thereafter, the defendant did not pay. The plaintiff sued the defendant for the recovery of the commission. Judgment. The court rejected the plaintiff's prayer. It held that the act of construction was resulted by the collector's orders but not from the promise of the defendant. Third one. Privity of consideration. Consideration may move from the promisee or any other person under the English law. The consideration must move from the promisee only. Under the Indian law, consideration may move from the promisee or any other person, that is, even a stranger. Consideration number 4. Consideration may be past, present, or future. Section 2D provides that the consideration may be past, present, or future. Present consideration. When consideration is given simultaneously with promise, that is, at the time of the promise, it is said to be present consideration. Section 2D, does or abstains from doing, shows the consideration for the present tense. All cash sales are the examples of this type. Past consideration or executed consideration. An act which has already been done in response to the promise is called as an executed consideration or past consideration. The words in section 2D, has done or abstained from doing, denote the consideration for the past. When consideration by a party for a present promise was given in the past, that is before the date of the promise, it is called past consideration. Under English law, past consideration is no consideration but Indian law is liberal and flexible in this regard. Illustration. A is a doctor, B is a patient. B was brought to A's dispensary. A renders his services for 10 days. After 10 days, B promises to compensate A for the services rendered to him. It is past consideration. A can recover the promised amount. Coming to future or executory consideration. The words in section 2D or promises to do or to abstain from doing denotes the future consideration. When consideration is from one party to the other, is to pass subsequently to the making of the contract. It is future or executory consideration. Illustration. A is a bookseller and B is a publisher. A requests B to deliver some books to him within 10 days and he would pay the amount of the books after 1 month. B agrees. It is future consideration. Let's see a problem. X, a student, aged 19 years, living in a hostel, agrees to pay his postman rupees 10 per month if he delivers his letters promptly. Whether this agreement is enforceable? Solution. No, it is not enforceable. Paying rupees 10 more or less to a postman who is a government servant is not valid and lawful consideration. It can be treated as corruption. Therefore, such an agreement is not enforceable. The last one, adequacy is not essential. Consideration means something in return. The something in return need not necessarily be equal in value to something given. The law in this regard in India and English is the same. The courts will not inquire into the adequacy of consideration. Courts adhere the principle that consideration need not be adequate but must be real. Illustration. A gave rupees 25,000 to B on loan at 2% monthly interest. After 1 year, the loan was repayable with interest. After 1 year, B could not pay the principal and interest. A expressed his willingness to take rupees 20,000 and forego rupees 5,000 and interest thereon. It becomes a valid consideration, though there is no full consideration. But the condition is that there must be free consent and valid execution established. Problem 1. Ramesh agreed to sell his scooter to Mohan for rupees 200 as he was badly in need of money. Later, Ramesh refused to give the scooter and offered the return of money. In a suit by Mohan, Ramesh pleads that the agreement is invalid as consideration is inadequate. Solution. The contract is valid as Ramesh agreed to sell his scooter for inadequate consideration with his free consent. The agreement had become valid agreement. Now after taking the consideration, that is rupees 200, he cannot plead inadequacy of consideration. Problem 2. A agrees to sell a car worth rupees 2 lakhs for rupees 20,000 to B and later denies that his consent to the agreement was freely given. Explain the validity of the agreement with the help of relevant case law. Solution. The contract is valid. Inadequacy of consideration does not defeat the valid contract. If A argues that his consent to the agreement was not freely given, then the burden of proof lies upon A to prove under what circumstances, that is any one of the elements of undue influence, coercion, misrepresentation, mistake, etc., he was compelled to give his consent. Number 6. It must be real and competent. The consideration must be real, competent, and of some value in the eyes of the law. There must not be physical impossibility, legal impossibility, uncertainty, and illusory consideration. Seventh one, it should not be illegal. Consideration must not be illegal, immoral, or opposed to public policy. This is based on section 23. Excuse me. Forbearance to sue. It may be an act, abstinence or forbearance, or a written promise. Forbearance to sue, compromise of a disputed claim, composition with creditors are the examples of this act and constitute a good consideration. Should not pertain to an act of duty. Consideration should not pertain to an act of duty. It must be something which the promiser is not already bound to do. A promise to perform a public duty by public servant is not a consideration. He is bound to do his duty. Now, exceptions to consideration. The basic principle is that an agreement without consideration is void. However, an agreement made without consideration is enforceable under these occasions. These circumstances are provided in section 25 itself. Number 1. It is in writing and registered. The beginning words of the section 25:1 say, an agreement made without consideration is void unless it is in writing and registered. Give the meaning that if the promise is made and it is put in writing and registered under the law for the time being in force for registration of documents and is made on account of natural love and affection between the parties standing in a near relation to each other is lawful and binding. Illustration. A, for natural love and affection, promises to give his son B ₹1,000. A puts his promise to B in writing and registers it. This is a contract. All gift deeds are the examples of this clause of exception. Transfer of Property Act provides that all gift deeds pertaining to immovable properties must be registered. For the registration, the provisions of the Indian Registration Act 1908 and the Indian Stamp Act 1899 are applicable. Second case, it is a promise to compensate for something done. According to section 25(2), an agreement made without consideration is void unless it is a promise to compensate, wholly or in part, a person who has already voluntarily done something for the promiser or something which the promiser was legally compellable to do. Illustration. A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. Third case, it is a promise to pay a debt barred by limitation law. According to section 25(3), an agreement made without consideration is void unless it is a promise made in writing and signed by the person to be charged therewith or by his generally or specially authorized in that behalf to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law for the limitation of suits. Illustration. A owes B ₹1,000, but the debt is barred by the Limitation Act. A signs a written promise to pay B ₹500 on account of the debt. This is contract. So this is all for this video. Hope you all liked it. If so, please subscribe and share. And also a caution here, like whatever that we are reading out is from the material or the books, whichever the information which is available with us. And the listener is always suggested to cross check and verify with the content whatever you have. And we do not claim any authenticity for this. Thank you. Please subscribe and encourage.